No,
And is there any medication that you take on a daily basis or regularly that you haven't taken today that would affect your ability to understand why you're in court today?
no.
Okay. And ma'am, how old are you and how far have you gone in school?
I'm 34 years old and I have my GED.
Okay. And are you able to read, write, and understand the English language?
Yes,
Okay. Do you understand that currently you are charged with the following offenses in indictment number 22 SC 182150? Counts 1 through 3 are felony murder charges. Counts 4 and 5 are aggravated assault with a deadly weapon charges. Count 6 is criminal damage to property in the first degree. Count 7 is possession of a firearm during the commission of a felony. And counts 8 and 9 are both possession of firearm by a convicted felon. Do you understand that you are currently charged with all of those offenses in that indictment?
yes,
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
yes,
Okay. And have you had an opportunity to go over the waiver of rights form that you were speaking with your attorneys about outside the courtroom?
yes.
And is there anything on that waiver of rights form that you went over with both your counsel, Mr. Bernard and Mr. Melnick, that you need more time to speak to them about or don't understand?
Okay,
Yeah, so in other words, they tell you what you're charged with, but you're only pleading to the 2 firearm charges. You got it? Yeah.
Hmm.
Okay. Do you have any other, so you need to answer the question. What was the last question? Is there anything?
Do you
about
have any-
waiver of rights that she didn't understand? Is
Yes.
that right?
So any questions about the form that you went over with your attorney?
no, I understand.
And after going over each point of the form, did you initial and then sign on the back of the document indicating that you understood the rights that you were waiving and the entire form?
She has not signed it yet, but we're going to do it right now.
Okay.
So,
And you should have the indictment, the 22 SC indictment.
We got it.
Let's make sure we sign that as well.
Yeah.
Please.
And are you satisfied with the services of both of your attorneys, Mr. Melnick and Mr. Bernard?
Yes,
And counsels, do you waive formal reading of the indictment
we do.
as well as any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
Yes, I'm not aware of any defects, but yes.
And Ms. Maribel, has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading guilty to? So counts 8 and 9, possession of a firearm by a convicted felon.
So you have to answer the question.
yes,
And did they inform you that the minimum is 1 year, the maximum is 10 years?
yes,
Okay. And do you understand that this is a negotiated plea of guilty, which means that the state and your counsel will recommend a joint sentence to the court, but the court does not have to follow this recommendation and can sentence you as he sees fit and can sentence you to the maximum or the minimum for each charge and then run them consecutively or one after another?
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal court?
yes,
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by either of your counsel or anyone else?
yes,
Do you understand that you waive any and all defenses by entering a plea of guilty here today?
yes,
And do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after a trial. Do you understand that you are waiving or giving up all of those rights today by entering a guilty plea?
Yes.
And Ms. Maribel, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
And is it your decision to waive these rights and enter a guilty plea because you are in fact guilty of the counts you're pleading guilty to?
Yes.
How do you plead to the charges in indictment number 22 SC 182150, count 8, possession of a firearm by a convicted felon?
Yes.
And how do you plead to count 9, also possession of a firearm by a convicted felon?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, ma'am?
Yes.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea?
Yes.
You gotta speak loud.
Yes.
Okay. Your Honor, had this case proceeded to trial, before I do that.
I've got everything on there, but if there's anything of the indictment, has she signed it yet, Mike?
Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on December 24th, 2018, around 8 p.m. on Christmas Eve, the defendant, Ms. Maribel, had driven over her co-defendant, Mr. Donald Roberson, and her at the time significant other, Mr. Bartholomew Smith, who his nickname was Sin.
Just so I want to make sure I follow this from the get-go. Mr. Roberson was Ms. Maribel's significant other, or Mr. Smith was the significant other?
Mr. Smith, I apologize.
No, you I just didn't know where the comma was in the sentence. Okay.
Earlier in the day, on Christmas Eve, Mr. Roberson, who is Miss Maribel's cousin, also goes by Pokey, had been playing dice and gambling over at 1190 Oakland Lane here in Atlanta, Georgia, Fulton County. During that dice game, he had won $5, and he was playing with 2 other individuals who were also visiting friends within the complex, Mr. Corey Miles and Mr. Devon, which is D''VON, cousins. And after the dice game ended, Mr. Miles still owed Mr. Roberson $5. Mr. Miles didn't have the $5 and said he wasn't going to pay. And so Mr. Roberson left upset and said he'd be back. What the evidence would show is that Mr. Roberson then went down the street in his black SUV and went to where the defendant was living, Miss Maribel, who was his cousin, and told him, or excuse me, he told her what happened. And at that time, Miss Maribel called her significant other, Mr. Smith, and said, you need to come over here. We need to go take care of something. They're disrespecting Mr. Roberson. They didn't pay him the $5. And so at that time, Mr. Smith, who was at home with his family, his sister, who was in the courtroom here today, Miss Jackson, and they were getting ready to open gifts on Christmas Eve and then go to their mother's house with her grandchildren and to continue the celebration for Christmas. He left and went and picked up Mr. Roberson and Miss Maribel, and they drove back to the 1190 Oakland Lane address. And at that time, when they got there, Miss Maribel was driving. What they did was Mr.
Maribel was driving. So Smith actually came to pick them up, Roberson and Maribel, but then Maribel took the wheel.
Yes, and I apologize. So Smith came to pick them up. What happened was they decided that Smith's car was going to remain there and they were going to take Donald Roberson's black SUV.
The black SUV, which Ms. Maribel drove back to the dice game.
Yes.
Okay, with Roberson and Smith in the SUV.
Yes.
And presumably a gun or guns.
Yes.
Okay.
And once they arrived, Mr. Miles and Mr. Cousins were both sitting inside his Dodge Charger in the parking lot parked. The evidence would show from witness testimony that they parked behind to where they blocked that car in to where he couldn't leave. At that point, Mr. Roberson and Mr. Smith got out of the black SUV, and Mr. Roberson began to, I guess, yell at Mr. Miles and Mr. Cousin about the $5. And then Mr. Miles, like I said, had gotten out of the car. He had gotten out of the car wearing a mask of some sort, a ski mask, and he was armed with a firearm and began to shoot into the car.
So your understanding of the evidence is that Miles, the guy who owed the $5 and said, I'm not going to pay, starts shooting first.
No,
No.
so I apologize.
That is what you said, but
Okay.
there's dispute about it.
Okay. And we'll get to that.
So my apologies.
Okay.
So if I said that, I misspoke. The person who
Who
shot
was wearing the mask?
Mr. Smith.
Okay. Mr. Smith was wearing the mask.
Yes.
Okay. And he has a gun
Yes,
and he starts shooting.
he does.
Okay. So Smith and Roberson get out of Roberson's car. Marable is at the wheel.
Yes,
Smith's got the mask on. He's got a gun, starts shooting in the direction of the Charger that has Cousins and Miles in it.
that's correct.
Okay.
After Mr. Smith begins to shoot, that's when Mr. Miles, Mr. Cousin, they bail out of the car. Mr. Miles is armed with a firearm. He begins to fire back, and they both run in the direction of the street to try to, take cover. At that point, when Mr. Miles was shooting back at Mr. Smith, he was struck in the chest and immediately went down. At that point, members of the community did call the Atlanta Police Department. What the evidence would show is that Miss Marable then gets out of the driver's seat and goes to Mr. Smith and
Her boyfriend.
yes, takes the weapon off of Mr. Smith and some sum of money, and then gets back into the vehicle and drives away. At that point,
What's Roberson doing at this time?
he leaves with her.
Okay.
They both get.
Did he fire?
He did not.
Okay. Did he have a gun?
There's conflicting testimony as to whether some say yes, that they both had guns. Others say that Mr. Miles would say that he never saw a gun in Mr. Roberson's hand.
Okay.
The only person he saw with a gun and fire was Mr. Smith. the
And is
deceased.
Mr. Miles, if he were to testify, would he say, and I know it was Smith, or it was some guy with a mask, but I'm guessing it was Smith because he and I had this beef over the $5.
So he would say that he knows it was Smith, and that Smith was there to avenge the beef that Miles had with Mr. Roberson.
Oh, right. I'm sorry. That's right. The beef was with Roberson over the money, and it was Ms. Marable who brought Mr. Smith into the mix to help right this alleged wrong.
Yes,
So Miles would independently know Mr. Smith from the neighborhood, not just because of this incident.
yes.
Okay.
From there, Your Honor, members of the Atlanta Police Department did show up. Mr. Miles was taken to Grady Hospital, but unfortunately, he did not survive.
Mr. Smith.
Mr. Smith, yes, sorry about that. Mr. Smith did not survive the shooting. And at that point, investigator Jerry Shepard was assigned as the lead detective, and he began to canvass the area and speak to witnesses who had called 911 and also who had remained on scene. He was able to get in touch with Mr. Miles and Mr. Cousins, who were both inside of the blue Dodge Charger when Mr. Smith began to fire. And that's how he learned of Miss Marable's identity. From there, he continued to investigate and spoke to friends and family members of Miss Marable. And one of the individuals who he was able to speak to was a close friend and also the downstairs neighbor of Miss Marable, Miss Treon,
Treon Terry.
Treon Terry, and that's Treon. That's how you spell her first name. And at that point, Miss Terry was able to tell Detective Shepard that on the night of the incident, Miss Marable had called her, asked her to take anything that was illegal out of her apartment and bring it to her at the corner store up the street. At that point, Miss Marable was interviewed by Detective Shepard and did admit that she was on scene. I would say but the evidence would show if her statement was presented to the jury that she minimized her involvement. But based on the evidence, her involvement was she was the individual who connected Mr. Smith or Sin into the situation and transported him over to the scene. In speaking with both defense counsel and the circumstances of the entire case, looking at it from the totality of the circumstances, we were able to come to what I believe is a reasonable resolution where Ms. Marable would plead to, again, counts 8 and 9, the possession of a firearm by convicted felon charges. And the recommendation would be in total for both charges, 10 years to serve. So for count 8, it'd be 10 years to serve, and then count 9 would run concurrent for the same amount of time. The second charge is based on the fact that Ms. Marable was arrested on October 29th, 2019. And when she was arrested, she was also in possession of a pink Glock 9mm firearm, which she took custody of.
So
Did I say October?
the indictment says January 29th, so it would have been sort of about a month later. Maybe
Yes.
that's when she was arrested in connection with this case, but regardless, it was a month later as opposed to 10 months later.
Yes, I didn't mean,
Okay.
I meant to say January if I said October, so I apologize.
Okay.
And so that's the basis for the additional charge in which the state re-indicted fairly recently for this charge.
The pink gun is not the gun that you believe was used by Mr. Smith to shoot at Cousins and Miles.
I don't believe so, no.
Okay. And was that gun ever recovered?
It was not, no, it was not recovered.
Okay.
The last information that was received about that firearm was that Ms. Marable had taken it off of the deceased body and then fled the scene. It
Okay.
was never recovered.
And Mr. Miles was not prosecuted because your office and law enforcement concluded that that was self-defense.
Yes, Your Honor.
And your review of the evidence is that it is pretty clear that Mr. Smith was shooting first.
Yes, Your Honor.
Okay. All right. That's a complicated set of facts. Mr. Roberson maybe had a gun, maybe didn't have a gun. Mr. Miles would say he didn't think he had a gun, but no one says Mr. Roberson, and I appreciate this is not his case right now, it's Ms. Marable's, but there's not a witness you are aware of who said, well, actually Roberson was shooting also.
There is a witness who from a window says that everyone was shooting.
Okay.
But
And then
no
maybe
one-
even Cousins was shooting.
Correct.
Okay.
But
Marable?
No.
No. But 4 guys shooting.
Yes, during the shooting, it's very clear that all witnesses say that Ms. Marable did not get out of the car. She was the driver and remained in the driver's seat until the shooting has ceased. And
Mr. Smith was down.
yes,
Okay. All right. I know there are family members of Mr. Smith's here. Do they want to speak, or is there a victim impact statement they've provided any of the victim witness team?
there are 2 family members, his aunt and his sister, Miss Jackson, who'd like to make a statement when the court deems appropriate.
Sure. Did you have more? I don't want to cut you short. I'll certainly hear from Ms. Jackson when you're done with your presentation.
I've said more than enough. I'll tender for the court both the signed indictment as well as the plea of guilty form signed by all parties.
Thank you. And assuming the plea goes through, you are null prosing counts 1 through 7 for Ms. Marable.
Yes, and as well as the
The
19
old
SC
indictment.
case.
Got that. Okay.
And then obviously, I think it's count 10 that doesn't apply to her at all.
Correct. That is Mr. Roberson only. All right, Ms. Jackson, if there is something you want to say, or anyone else, but anyone from Mr. Smith's family, or say it through the victim witness advocate, now would be a good time to come. And you can stand right at the, if you come a little closer, because court reporter needs to be able to hear you. And if you don't mind taking your mask off while you talk, that'll help us hear you. Tell me who you are, please, and your connection to Mr. Smith.
My name is Linda
The only thing you
Smith.
claim to-
Okay, you're not Miss Jackson. Sorry. Okay.
So
And I am the aunt.
I am
of
going
my
to talk
daughter's
about the
she-
discrepancies.
He was my brother's son.
Circumstances, okay?
And I have a
That's
statement
the thing you need to.
from his mom, Janella Curry.
No,
for Ms.
unfortunately, my
Garrett.
family was dead. His family was-
So it's important that you talk to me. The words can be directed at whomever, but just so we keep things flowing in the right direction. You and I are having a conversation. I'm confident Ms. Marable is listening, and if she's not, she's making a poor choice.
I just want you to know that I feel that you played a major part in my son's death. I don't understand your reason for doing what was done, but I feel that you should pay for the part that you played in his death. My son is gone because of your actions. I will never be able to see him, talk to him, or hug him again. His 36th birthday was on May the 2nd, and I was not able to wish him a happy birthday. He took his life on Christmas Eve of 2018 because of your actions. I mourn on this holiday now. It's very hard to celebrate Christmas. He was not only my son, he was also my friend, and he meant the world to me. Bart was my oldest son. His youngest brother was also killed 5 months after you killed Bart. He was lost without his big brother, so I'm grieving for both of my sons. We had some wonderful times, but now all I have is memories and pictures. I don't know if you are a mother or not, but I don't feel that you should be allowed to enjoy your family after you helped to destroy mine. And I feel that you should be given the maximum time for your actions and part in the part that you played in the murder of my son. Thank you for giving me the opportunity to speak on behalf of my son.
Thank you for speaking on behalf of Mr. Smith's mother. I appreciate that. Good morning.
Morning.
And you are,
Carmel Jackson.
you're Miss Jackson. Okay.
I spell CHARMEL Jackson.
And your connection to Mr. Smith,
I'm his sister.
his sister. Okay. What would you like to share with me?
And first off, I would like to thank the court for giving me the opportunity to speak about my felony. I call him Sin. And from the day that I picked him up from prison, and I was sitting in the car, it was like a long ride, but we talked and he was speaking about how he wanted to make changes in his life. And despite his outer exterior, where he had the tattoos and all of that, he did have a past, like we all do. But I did see him transition once I brought him into a place called home. He started to do things around the house. He started to mount TVs, fix the water, fix the dishwasher. He was engaging with my grandbabies. He went with my daughter to have her second child, and he used to babysit. And anybody who knows the temperament of a person, if children can cling to you, that means you have a good spirit on the inside, despite things that you've done in your past. And he actually engaged with my family. And on that day, we were actually doing open gifts. And he got so emotional because he said he never received Christmas gifts from anybody. He's always one giving out. And he like hugged us so hard that day, like he kind of maybe felt something in his ear. I'm not sure. But he hugged us so hard and he was emotional and he cried. And he was thanking all of us. And my son, who has autism, he's really like withdrawn. So he's not really a social person. He went in his room and Sam went in the room and got him out, and he just hugged him. And my son, I see my son put his arm back around him, and I was like, okay, no, my son is actually coming around and everything to him and getting soft with him. And so that day, we did not know that was going to be the last day that we would be engaged as a family. And so it's hard because that day was Christmas Eve, which is also my sister's birthday. So I can't really celebrate my sister's birthday because I remember all the events from that day, and it's really hard for me to go forward from that. But I would like to say that the people who are responsible, which is Ms. Marable, for one, I'm very well aware that should be accountable for the things that she did to bring him away from us, because she knew the temperament that he has for a loved one, and she considered herself to be his better half. So she was around him enough to know if you say somebody's trying to do some harm to you and you call for him, he's not coming to have a conversation. You know why he's coming. And so I know with her knowing that, when you call him, you knew it was a chance of that. You took him away, not just yourself, but from us as well. And I just would like to say he will forever be missed. And I said, I made a promise to myself, no matter what they tried to wipe it off the books as, I know what happened that day. And I didn't want somebody to be accountable for taking him out of the house, because we were celebrating Christmas together. Thank you very much.
Thank you, Ms. Jackson. That was a real valuable insight into where your brother had gotten. And it sounds like he had turned an important corner in his life. And I'm glad that there was that family moment. I know you won't get that back, but hopefully today, and there'll be another court event because we've got the co-defendant, but that will bring some closure and some relief. It won't cure everything, but maybe in the future it will be a little easier and people can remember things like the good part of that Christmas Eve. All right, thank you.
Thank you.
Mr. Abate, anyone else? Okay, thank you so much. Before I turn to Mr. Melnick and Mr. Bernard, Ms. Jackson, do you have criminal history information for Ms. Marable?
Yes, Your Honor. The defendant has 11 cycles. The defendant's last arrest was February the 5th, 2015, with Bowling Green Police Department in Kentucky. It was for criminal possession of forged instruments in the second degree. There was no disposition for that arrest, Your Honor. The defendant did receive first offender treatment in 2006 for possession of controlled substance, 2 counts. It was sealed May the 2nd, 2011. And there is 1 misdemeanor conviction that was in 2019 for simple battery. The defendant does appear to have 2 holds. There's one out of Bowling Green, Kentucky, for a failure to appear. The date on that warrant is June the 9th, 2015. And also there's one out of Baton Rouge, Louisiana, for parole violation. The date on that warrant was November the 30th, 2017. That conviction was not listed in the GCIC, Your Honor. Nothing in addition.
Okay. One question, and thank you for that. That was very helpful to get the multi-state perspective. The first offender that is sealed, was that a Georgia case or is that out of another state?
That was out of Georgia, Your Honor.
Okay. Do you know what county?
Fulton County.
Fulton County. Great. Thank you so much, Ms. Jackson.
Yes, sir.
All right, Mr. Melnick.
Thank you, Judge. Good morning.
Good morning.
So Miss Marable is 34 years of age. She has 2 children, ages 17 and 12. She has a 5-month-old grandbaby. As you can hear from her history, she does have some history, but certainly nothing that indicates any violent criminal past.
I think that I agree with you. The Louisiana conviction we know a little bit about because it's mentioned in the indictment, and it sounds like it's a forgery fraud type thing as well. So it's not a robbery or an assault. It's more fraud and theft.
So what really brings us here, candidly, Judge, is the fact that in Miss Marable's statement, she admits that she went to the scene where this shootout took place. But in all candor, it is the defense perspective that the primary individuals involved for this incident are the people who are now witnesses or would be witnesses for the state. Corey Miles had a prior conviction for possession of a firearm by a convicted felon prior to this incident, 2 subsequent convictions for possession of a firearm by a convicted felon. Devon Cousins had a prior felony conviction. I don't remember what it is off the top of my head, but he subsequently pled guilty to robbery and aggravated assault and received a 10-year prison sentence and is currently in the Department of Corrections. And it is our contention that they were the primary aggressors in this matter.
When you say that, just so and maybe you're going to flesh this out, but what Mr. Abate described is Ms. Marable, Mr. Roberson, and Mr. Smith coming to the trouble. And if you think that it's a different set of facts, maybe you're getting there. But it could be that Mr. Cousins and Mr. Miles aren't real nice guys, and they have criminal pasts, and they've have since then been in trouble. But if the facts are because Mr. Roberson is chapped because he's owed $5, that your client brought Mr. Roberson and Mr. Smith to these bad guys, it doesn't really matter how bad those guys are. Why'd you go there?
I agree, and that's kind of why we're here doing what we're doing today.
Okay.
That's where Ms. Marable would have an issue in trying this case, candidly. But this is an area where she would frequent. It wasn't like this is the first time she'd ever been there. This is an area where
Everyone knew everyone.
Right. That's exactly right. Yeah. So it's a very difficult situation, Judge. It's been difficult for her. You can see what we've been going through with her this morning. Where we kind of are with this case. The offenses that she's pleading to are offenses that the state, I think, can prove.
Unquestionably.
Yeah. So whether the sentence is just given what her involvement may have been, that's a matter, I guess, for you. But this is what we've negotiated, and this is what we are agreeing to. And obviously, there's a lot of disputed facts about this case. Miss Marable actually left the scene on foot, and that's what Treon Terry, who I interviewed extensively, would say. Treon Terry actually came to get Miss Marable from a location in between where Miss Marable lives and where this incident is. What Miss Marable told the police is that, yes, she went there with Donald and with Bartholomew, but she didn't go there with any intention whatsoever of it being a shootout or anything like that. Right. Mr. Bernard has her child, Miss Marable's child, was actually at the apartment.
The 17-year-old or the 12-year-old?
17-year-old.
Okay.
Who was 13 at the time, 13 or 14 at the time, because this was December of 2018. That's where and she has other family members that were there as well. So it was not unusual for Miss Marable to be at this location. Okay. And there was never any intention of having Bartholomew get involved in a shootout. And we do believe that the primary aggressors in this matter were Corey Miles and Devon Cousins. I will point out that Mr. Miles and Mr. Cousins did not remain on the scene. They also fled the scene. And the reason they came to the police attention is because Mr. Miles' car remained there. And the police interviewed him sometime. I don't remember exactly what the gap in time there was, but it was at least several days, if not a week or longer, before Mr. Miles was interviewed. So, I mean, Judge, you've probably seen people in situations similar to Mr. Miles and Mr. Cousins who have been charged with felony murder. They're both convicted felons. They were both in possession of firearms, if nothing else, but Judge, there really isn't much more I can say about the case. I mean, it's a negotiated plea. We are asking that you accept the plea as negotiated. Miss Marable, unfortunately, has to pay whatever price she has to pay for whatever her involvement was. But as Mr. Abadi recited during, his presentation, there is certainly no evidence that Miss Marable got out of the car with a gun or anything like that. And it was certainly never her intention for Mr. Smith to be shot or to be involved in a shootout that day. And this could go into a whole deeper discussion about, people just this seems to be how conflict resolution goes these days. And it's bad for everybody involved. But that's all I have to say, Jim.
Okay. Well, I agree with that last point that this isn't a good outcome for anyone. But it's clear to me that you and Mr. Bernard have helped Ms. Marable understand that if this went to trial and a jury concluded that Mr. Smith was in fact the aggressor, the way felony murder works, even though Mr. Smith is, and I'm putting this crudely, was on Ms. Marable's side, and he's the one who died, legally, she would be liable for felony murder, potentially. And if the jury connected the legal dots, it's convoluted, but it's legally accurate, then she'd be looking at a life sentence,
Yes.
Which is very, very different from a 10-year sentence where she'll be parole eligible. So instead of 30 years before pardons and paroles even looks at your file, this is it's not a happy outcome. Not sugarcoating anything, but it is a very, very different landscape than what could happen at trial. I don't know what the jury would do. sounds like the jury would likely take a dim view of the whole thing because of the approach to conflict resolution. So I appreciate your observations on this. I don't think there's anything clear that could be said about this other than that it was tragic that there was the loss of life. And we've already heard about how that has affected people. And it must have affected Ms. Marable. This was her boyfriend. So it's not like her goal in this process was to have Mr. Smith get shot. Mr. Roberson may have some other things to explain, but that's not who's in front of me right now. Was there anyone, when you came in officially, about 20 people came in with you, is there anyone who wants to be heard on Ms. Marable's side, or you are the spokesperson for Team Marable?
I think that we've spent enough time talking about the case.
Okay, all right. Ms. Marable, do you have any questions for me about anything that has been discussed?
No.
Is there anything you want to add? You have a right to say anything you want because this is your sentencing, not or plea and sentencing, not anyone else's. But you also don't have to add anything to what Mr. Melnick and Mr. Bernard have already said on your behalf.
I just feel like I apologize to the family, even though like the stuff that they saying wasn't true. That was my friend. I loved him also. I'm hurt also. My kids hurt also because they was attached to him. And I accept my plea, but I took a loss too. This was somebody I love. I didn't take him nowhere to do nothing to nobody. Like this someone I love. My children was outside playing. My little brothers was outside playing. My little cousins was outside playing. I would not take my boyfriend nowhere to harm nobody where kids are around. I would take nobody nowhere to harm nobody, period. But I accept my plea.
Okay. Well,
I apologize to his family.
Well, and that's,
because they hurt and I'm hurt also.
well, I think it's important you said those things, in particular, the apology. Many people in this room weren't there when it happened. And so they are speaking based on information that's been relayed to them. So I appreciate that perspective. I will tell you, I also appreciate Ms. Jackson's observation that she knew, and she believes you knew, and I bet you did, given how close you were to Mr. Smith, that you don't bring Mr. Smith to a situation as the diplomatic negotiator. And that to me spoke volumes about what was happening with that situation when Mr. Roberson returned to it with you and Mr. Smith. But I also understand, Ms. Marable, that in your mind, this was about trying to work something out and not all of a sudden it's the shootout at the OK Corral, because it sounds like bullets were going in all sorts of directions. And if there's anything we can be thankful for, it's that no little kids got shot when that started happening. But there was still tragedy. I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means that even though this is not a happy moment for you, after you have consulted with both of your attorneys and your family, you have decided on your own, with their advice, that it's in your best interest to go forward with a plea rather than to go downstairs now to courtroom 1D to pick a jury. Is that correct?
Yes.
Okay. And in terms of it being a knowing plea, that means simply that you don't have any questions left. And I will note for the record that throughout the exchange, while Mr. Abate was asking questions, you would periodically confer with primarily Mr. Bernard. He'd answer your questions. Sometimes it was Mr. Melnick, and then you'd answer. And so I felt that you were doing a good job of what I asked, which is consult with your lawyers if you didn't understand something, but that ultimately you made clear on the record that you understand what we're doing today. Is that a fair statement?
Yes.
Okay, then I will accept your plea. I will follow the recommendation in this case. Your sentence on count 8 will be 10 years to serve. Your sentence on count 9 will be 10 years to serve. They will run concurrently with each other. So that's a single sentence of 10 years to serve. I don't know how long you were in custody as a result of this, but you'll get credit for that time you were in. So I'm making it up. But if you were in for 4 months before you got a bond, those 4 months go towards that 10 years. If it was more than 4 months, it's more. But whatever those numbers are, the jail will know. They'll have your jail records, and that will get credited to the 10 years. We do have the issue of whether you're going into custody now or whether you're going to turn yourself in later. My understanding is that there is at least one valid warrant, and I cannot let you leave if there's a valid warrant. I'd ask the sheriff's office to double and triple check. You heard from pretrial services, and they've checked the systems and actually showed 2 warrants, one particularly old out of Kentucky. The one that was brought to my attention was the Louisiana warrant. Deputy Gordon, was your team able to verify that? Okay. So Ms. Marable, unfortunately, we don't get to have the conversation about how about 2 weeks? You're gonna need to go into custody now. I told your lawyers that if they're able to clear that warrant up, we could revisit the question about you doing some final planning. But for now, you're gonna go with the deputy and we'll fill out your final disposition today. Mr. Abate, anything else in Ms. Marable's case? Mr. Melnick?
No, Your Honor.
All right, thank you so much.
Do you want this or is this going to your phone?
I need,
Man, I can't keep giving her stuff when I'm trying to.
I'm sorry.
Just a piece of paper.
Yes, sir. Thank you. I will send an email, maybe. You're going to reach out to Mr. Theory, or should I reach out to him about maybe next Tuesday, closing up the rest of this?
I'm gonna reach out.
Okay, I'll let you manage that. I won't bug, and I will not bug you about Grant. You don't have Shari Grant, so I'll bug Ms. Beza about the phones.
I'll make sure she got that. I don't know who.
Well, she'll tell me if she hasn't. I mean, I'll copy the PD obviously as well. Okay, thank you. Good to see you. I hope you and Mr. Melnick didn't take the wrong way my weekend email. We needed to do what we needed to do, and I appreciate the 2 of you doing what had to happen, but this didn't need to roll over again.
Right. Well, yeah, we were pretty close, and I think that what it was primarily, I got tied up in that other case that kind of came up unexpectedly.
Well, you got pulled in several directions. You're in the cab, you had something potentially here. I get it. You both have lots of conflicting commitments. But I appreciate you leaning into this one.
Yeah, thank you.
You bet. Take care. Thank you, Ms. Jackson. Oh, she just dropped off. Thank you.
You don't want